Well, hello everyone and welcome to the first ever MyHR Facebook live event. So a couple of things to cover before we get started today. This is going to become a monthly event. So we're going to run one of these every month. Today's topic is on 90-day trial periods. That's in the context of New Zealand employment legislation. And future topics will be on pretty much anything that people are interested in. So we welcome your feedback, we welcome your ideas on things you'd like to know about, learn about, or understand a little bit more about. The whole idea of these things is to demystify some of the things in and around employment legislation in New Zealand and HR best practice. So these events will be available on our Facebook site after they're there, so you can access them whenever you like. We would encourage you to subscribe, to follow us, and to participate in them. Ask us questions. That's really a key to it. I can talk for ages about this topic, but it really comes to life when people ask questions. So in terms of an introduction and who I am, my name is Jason Ennor. I am the CEO and co-founder of MyHR. MyHR is essentially an outsourced human resources department for businesses of all sizes. We have a unique software platform that we have built and developed, and that's the bridge between our clients and our team of dedicated HR professionals. In terms of background and how am I even qualified to be talking to you about this stuff, I've spent about 15 years working in large corporate HR functions, typically at what I call the pointy end of HR. So that's dispute resolution, restructures, disciplinaries, union negotiations and such like. I have a real passion and interest in employment law, and we've applied that to MyHR. So MyHR is now about 4 years old. We have over 600 businesses around New Zealand using our services, as well as businesses in Australia, Singapore and the UK. We look after 12,500 employees. And we do everything pretty much that you can imagine in the employment relationship. So that's who we are, that's what we're all about. So let's get started on the topic of 90-day trial periods, because the law's been around a while, but we find that there is still a lot of misunderstanding about this particular piece of law and how it is applied, and that results in a number of disputes. So what I'll cover is some of the broad principles, some of, I guess, the rules that you really need to think about if you want to have a valid 90-day trial period in the employment relationship, and then also how you go about undertaking a 90-day trial period exit if the employee hasn't worked out. Along the way you can ask questions, or there'll be some time for questions at the end, and we will just run it as it goes. So I will look out for questions over here where I have a little monitor. You can just type them into Facebook and we go from there. So let's get started. Firstly, in and around 90-day trial periods, one of the things that is happening is a very, very strict interpretation of the legislation. So the case law is telling us that there is really no wiggle room to get it wrong. And that is fundamentally, I think, because the courts have identified that this piece of law removes the rights for employees to be able to take a grievance or to challenge a termination. And that is a pretty fundamental right in any kind of society based on natural justice. And so the courts have said, okay, well, that's fine. If this is the law, we will interpret that law incredibly strictly. And what we have seen is most of the grievances that relate to 90-day trial periods are grievances in which the employee has successfully challenged the validity of the trial period. And the courts have ruled that in fact there wasn't a valid trial period in place. So what do you need to make sure that a trial period is valid? And there are a few key things, and these are really non-negotiables. So first and foremost, this might sound obvious, but you must have a 90-day trial period clause in the employment agreement. And it must be a proper 90-day trial period clause. So sometimes we see, for example, the old probationary period clauses that are simply relabeled as 90-day trial period. That simply doesn't cut it. There's certain wording you must have. I'd encourage you to have a look at the Ministry of Business Innovation and Employment website, or ask us about these sorts of things. But there are some references to the Act that need to be included, and there are some specific references around the start date of the 90-day trial period, the duration, and the rights of employees and the process the employer may follow. So that's a fundamental. It must exist in the agreement. And then the employee must have signed the employment agreement with the 90-day trial period clause in it before they commence work. And to give you a bit of an understanding of just how strictly this is interpreted, there is a case relates, I think, to a coffee cart in the domestic terminal of Auckland Airport. or something like that, in which the employer presented an employment agreement to the employee prior to them starting. The employee didn't sign it. They turned up to work on their first day with the agreement unsigned, and the employer said, listen, you need to sign this before you start. Took them into a meeting room, and they signed it in the meeting room, and they commenced employment. A few weeks into employment, things hadn't worked out, and the employee was let go. When the grievance was taken, the Employment Relations Authority determined that because the employee had already got to work and was on the roster and had signed the agreement in a meeting room before walking out and starting to make coffee, that the employment relationship had already commenced, and therefore the trial period was not valid, and he won his grievance. And so that just shows you, when we say before employment starts, we literally mean before. 30 seconds of employment is too much, and a trial period will be found to have been invalid based on the case law that we have seen. So what we recommend is that it's signed and returned the day before. And this is where electronic processes can really help. You know, the old school approach of printing employment agreements and signing them in pen is fine, but it can really result in delays and exchange. It can mean employees turn up on day one with the agreement in hand and it may not be signed. In the case that I just referred to, I think the authority member said to the employer what they should have done is sent the employee home with the unsigned agreement and said, you can't start today. You need to review this agreement, seek advice, ask questions, and then sign it, and then you can commence work. So it's a very strict interpretation, but essentially before means before. They have to have it signed before they start. The second point around that is that the employee must have been given a reasonable opportunity to review the terms of the agreement, seek advice, and ask questions. And there's another case we refer to where an employer presented an employment agreement to somebody in an interview and said, look, we think you're great, we'd like you to start. Here's the agreement. If you sign it now, you can start tomorrow, which she did. Started the next day and then was let go in the trial period, and it was determined that the trial period was invalid because the employee hadn't had an opportunity to review and agree to those terms. Trial periods are voluntary provisions. They're not mandated in employment relationships. So the employee needs an opportunity to look at that, ask questions, seek advice, maybe seek to negotiate terms around that. And so best practice, people always ask, well, how long? We always say 1 week. And so that means if you want somebody to start with you, what are we today? It's Wednesday, Thursday, Tuesday. I lost track of that. It's on a Tuesday. So if I want an employee to start next week and I'm issuing an employment agreement today, ideally the start date is next Tuesday. So that gives them a full 7 days to review the agreement, ask questions and advice. Now, sometimes that instills a bit of panic in people. They say to me, 7 days, you're crazy, we're a fast-moving business, we need people to start straight away. 2 days is acceptable, and there is some case law in and around sort of 2 days or 48 hours being reasonable, but we strongly recommend that that does not include the weekend. Think in terms of availability of advocates or lawyers or people that an employee might speak to. And whether this is a realistic expectation or not, the law is sort of geared around that we all have an employment lawyer on tap that we might want to ring and ask questions of before we sign an agreement. So 2 days, but 2 business days. So in the context of the example I've just given, if you issued the employment agreement today, you could have somebody potentially starting with you on Thursday. Any less than that, we really don't recommend it. And that is simply because of the case law in and around having a reasonable opportunity to review the employment agreement. And look, if you think about it, for many people this isn't an issue. A lot of employees have a 1 month notice period or a 2 week notice period. There's generally plenty of time. And we really encourage you to try and make sure that there's a good quality and decent, robust recruitment process in place to mean that you're not involved in panic hiring and you don't have to be in a situation where you say, look, I want to put an employment agreement out today for a person to start tomorrow. Because that will, based on our experience, that will invalidate your trial period. Another thing is that the employee cannot have worked for you or been employed by you before. And this one's really interesting. So being employed means as an employee, obviously. And so that technically excludes, for example, temporary workers from agencies because they're not employed by you. They work for you through an agency. However, this hasn't really been tested in case law, and we like to advise our clients to err on the side of caution around this. And one of the things I'd sort of put to you is, if they're working for you as a temp, and let's say you've had them for 2 weeks or maybe 8 weeks or 3 months, and you want to offer them a permanent job, and you want a trial period, then maybe you're not totally certain that they're the right person for the job, in which case why would you offer them a permanent job in the first place? The great thing about a temporary worker through an agency is you have that ability to meet the needs of the business flexibly, to sort of try people out and figure out whether or not they're going to actually work in the job that you're looking at. So we actually advise just, don't even apply it to someone who's worked for you as a contractor or as a temp. Having said that, I've had this debate with plenty of lawyers who have said that that's not an issue. It's really only if there was a pre-existing employment relationship. But we just think it's worth being cautious, again, because of how this law has been interpreted. So that's another sort of important aspect of it. One thing and a question that we get a lot is in and around extensions, and the answer is pretty simple. You cannot extend a 90-day trial period. A trial period can be for up to 90 days from the commencement of employment or the employee's first day of work. So you can actually have a shorter period if you want. It could be 60 days, but it cannot be more than 90 days. And it cannot be extended on the basis of leave. So again, this is a question that comes up a fair bit. You might hire somebody new, they've got some pre-existing leave. Oh, look, I'm heading off to London for a month for my brother's wedding. Do you mind if I come in and do a month's work, take off for a month of unpaid leave and then come back? And that might be totally acceptable to you, that's fine. But just be aware that that 1 month where the employee is away is part of the 90-day trial period. It doesn't go on hold while they are away. So in that situation, you're left sort of weighing up a choice. You either say, well, look, maybe we'll just start you when you get back from London, or maybe we will accept that you have this period of leave pre-booked. We really want you to start. You'll come and do a month with us. We'll run an induction process and some training. You go away for a month. You come back to us, and you're now in the third and final month of that 90-day trial period. So just be conscious of that. Days off sick doesn't mean you then add it on. It's 90 calendar days from the first day of work. And that is the sort of fundamentals around the basics of getting an employment agreement in place and an employment relationship established where there is a valid 90-day trial period. And the case law that we've seen has been, as I said earlier, challenges to validity on all of these grounds. The agreement wasn't signed before the first day of work. The employee didn't have a reasonable opportunity to review it. The wording of the trial period clause was flawed. The employee had previously worked for the employer. Those are the sorts of things we're noticing. A trial period protects you from a grievance for unfair dismissal. It does not protect you from a grievance for discrimination or disadvantage. So that's something else to be aware of. And now this leads into the second part and final part before we go to questions of the use of or application of a 90-day trial period. And that is that your good faith obligations still apply. So you need to treat people fairly. You need to engage in a way that there is some active and open communication. And that helps demonstrate too that your decision has not been done on the basis of discriminatory grounds or done on the basis of disadvantaging the employee or as a result of disadvantage. And so typically what we tend to recommend is that when you run a 90-day trial period termination process, it's really run like you would run any other formal process. It's just somewhat condensed. And so by that I mean you actually sit down with the employee, you explain what you were proposing to do, and that might be terminate within the 90-day trial period provision, and you discuss why. You share that reason. It's not just a sort of blanket, fist on the table, you're fired, get out. It's a genuine discussion about the issues that you were having. And then you ask them for a response, that right of reply. Now, unlike a full-blown sort of formal disciplinary process, you don't have to adjourn and go through a sort of multi-day process. It can all happen then and there in that meeting. But at the very least, that right of reply is part of a good faith relationship, employment relationship. Listen to what they have to say and then work it out. And I've got to be honest, there are cases where when this happens, there are positive outcomes. That ability to engage somebody early. You don't have to wait to day 89 to do this. It might be in the first month. You've identified a bunch of concerns. You're starting to sort of worry a little bit and think, oh, geez, have I hired the right person here? I'm not sure they're right for this job. Things aren't really working out. Sit down and talk to them. Identify what's going on. Explain the issues that you're facing, and explain that in the context of the 90-day trial period, this could have an effect on ongoing employment. And then give them the opportunity to improve. And because we all know that recruitment is costly, it takes time, it takes a lot of effort. You don't want to be constantly recruiting. And I hear some commentators say that employers use the 90-day trial period to just turn over their workforce every 89 days. And I've got to be honest with you, I've never met an employer that does that, and I think that would be completely ludicrous that every 89 days you're going to re-recruit a whole bunch of people. You'd spend most of your time recruiting and not actually running your business. So, you want to limit the amount of times you use the 90-day trial period. So have the conversation. And if there is an opportunity to improve and figure out what's gone wrong, then maybe you don't have to terminate employment. Maybe you actually end up getting a good quality employee based on all of the great criteria you'd identified during recruitment. So, talking to people, it's pretty fundamental, really. And so that's the key in and around managing the process in good faith. You don't have to put it in writing. We often encourage that you don't. It doesn't need a letter confirming termination, unlike, say, redundancy or dismissal through serious misconduct or whatever it may be. This can be a verbal process. Again, provided you've sort of met all those predefined criteria around trial period validity. And so then that's really it, I guess, in a nutshell, from kind of the base rules to then how you might do it. I'm keen to answer any questions that anyone has, if you've got any. If I've covered everything, then that's great. If I think of anything else as we go, I'll chuck it in there as well, and we can sort of talk as we go. One of the things I have sort of noticed around, this, the misunderstandings, I guess, of the trial period is the amount of employers I encounter who think it's its own period of employment. Like you're employed for 90 days, and then if we like you, you are then employed permanently after that. That's not at all how it works. You're employed permanently from the moment you're presented a permanent employment agreement. It's just that the first 90 days of that employment is covered by a 90-day trial period, provided you meet all the criteria we've talked about earlier. So there's not this sort of process where at the end of 90 days you need to issue a new agreement or anything like that. The existing terms just roll over. So you don't have to actually do anything. What I would say as a matter of good practice and in terms of a decent induction, it's probably worth checking in. And throughout that induction, I would imagine you want to have weekly or monthly check-ins anyway to make sure your new employees getting things done, is up to speed, knows and understands what they need to do. And so the 90 days can be a nice sort of benchmark, opportunity, but legally you don't have to do anything in terms of triggering an ongoing employment relationship. There is an employment relationship already in place. The 90-day trial is not some sort of fixed term employment, if that makes sense. So there we go. Let me know if you've got any questions. I'm just going to hang out here for a little while and have a look at the Facebook feed over here to my right and see.
We've got one question, Jason. Melanie is asking, how do I instantly dismiss someone?
Yeah. Hey, Melanie. Thanks for the question. So in case you didn't hear the question is, how do I instantly dismiss someone? And that's a really good question. There really isn't any such thing as instant dismissal. That's a bit of a misnomer, sort of first and foremost. So, and this might sound a bit like legal semantics, but it is quite important. There is such a thing as summary dismissal, and summary dismissal can occur as a result of serious misconduct. And serious misconduct are the things that completely destroy trust and confidence in the employment relationship. This is the worst of the worst stuff. It might be stealing, it might be assault, bullying, harassment, sexual harassment, drug taking at work, serious health and safety breaches, those sorts of things. And a serious misconduct process can result in summary dismissal, which is effectively you're dismissed without any notice period. So at the conclusion of the process, dismissal is confirmed and the employee stops work then and there. They are paid up to that point, and they are paid any accrued holidays they have. That's still an entitlement. Any deductions from that final pay can occur where they genuinely owe you money. You can't just arbitrarily fine them. But that's the end. There's no notice period to be paid. So that's what summary dismissal is, and that's about as close as we get to the term instant dismissal, if you like. So even in a case of summary dismissal, though, there must still be a process followed. And we've dealt with some pretty serious cases, and it might be, for example, a case of assault. One employee bashes up another employee. You still in that instance do not have the right to grab them, march them outside and sack them on the spot. An investigation must follow, their opportunity to provide a response, their opportunity to seek advice. So the process will take a few days before you dismiss. So yeah, I hope that answers your question. Melanie, if I can give you any advice, it would be sort of move away from the terminology around instant dismissal. And then if you have a serious incident you need to deal with, probably get some advice.
Awesome.
Good question. Alrighty, I think we're going to wrap it now. I think that's been a pretty cool first session. No doubt we'll learn a lot from it. For those of you that have watched, again, please give us your feedback, good and bad. We'd like to hear it all. The first one is always the one that you look back on after a few months and kind of cringe at. But I've had a bit of fun and I've enjoyed answering the question that came through. If there are topics you'd like us to cover, let us know. Follow us, subscribe, join up, look for these on our resources page, and of course if you've got any other questions, feel free to get in touch. All right, thank you very much.